every person who is charged with a criminal offense is entitled to defend himself in person or by a legal practitioner of his own choice.
Remember that an individual is entitled to remain silent.
Every citizen in Nigeria is entitled to maintain a private life.
You are approaching a military checkpoint or a police checkpoint without knowing that it's against or it offends them and subject you to a frog jump. That is wrong.
Hello, you're welcome to another fresh episode of the program Justify Nigeria on ACNN television, reaching you from Abuja. On today's episode, our focus will be on the legal relationship between a landlord and a tenant, part 2. My name is Anoze Chinomso. It is a common knowledge that once there is life, man is bound to acquire properties such as land, cars, house, and so on. However, certain things that happens in life reveals that some problems that exist between man and his fellow, especially when it comes to landlord and tenants, is totally uncalled for. This is because if both parties, in this case, landlord and tenant, keep their own part of covenant as contained in the agreement, certain issues will not arise at all. Unfortunately, people find it difficult to keep to the terms and conditions of a legal paper, thus being in breach of the whole process. In one of the previous episodes of this program, we x-rayed and dissected some of the legal ways to stabilize the relationship between the landlord and the tenant. But up till now, legal disputes and disagreements between certain landlords and tenants still rages on. What could be the problem? How can this issue be settled or better managed? Is there any way to bring a lasting solution and peace to this? What are the better legal options and ways to cement the relationship between the landlord and the tenant? With me in the studio to address all this issue is Barrister Obi Naonya, Senior Associate at Dr. Onyechi Bazo SAN & Co., Member Chartered Institute of Arbitrators, who is also an Abuja-based legal practitioner. You're welcome to the program, sir.
Thank you very much, sir.
You are here again, Barrister. Yes, thank you very much. And we talked about landlord and tenants and the issues that arise from that. But now today, please tell us, are there certain rights and duties of the landlord and tenants?
Okay, so like we had discussed.
Yes.
Earlier, a tenancy relationship, a tenancy agreement must not be in writing. However, it could be oral. But it's important to have it in writing so that in the tenancy agreement, you will spell those rights and obligations there. So at a glance, a person sees his duties to the landlord sees his duties to the tenant. Now, we are now working on the presumption, or two things. We first address the general obligations, the general rights of a tenant and that of the landlord. This is notwithstanding what the parties will now agree in their tenancy agreement, because there could be those rights which inure to the parties by operation of law. That is the rights the law presumes, or those contained in the statute, like the tenancy law or the recovery of premises law, the various laws that regulate the landlord-tenancy relationship. Now, in addition to those ones, the parties can also agree special rights. Some of the rights that the tenant has is rights to privacy of the property. So once a landlord has rented out the property to the tenant is now the occupier of that property. And the landlord cannot go in there to say, oh, I want to check something in the property. I want to do something there without the consent of the tenant. So that if the landlord wants to do anything there, he must give the tenant notice to say, oh, please, I want to do this.
But it is the house of the landlord.
Yes.
Why must he not give you notice?
Yeah, because the tenant is now at law, legally in possession of that property. The landlord does not have access to that property. He can't even have the keys into the tenant's own apartment, for instance. Okay, he needs the consent of the tenant to do anything there. Other rights the tenant has, the landlord must ensure that the property is in tenantable state. Make sure that it is clean, it is not
habitable.
Clean. It's habitable, yes. Because if a tenant rents the house and the roof caves in, okay, the landlord is liable because he did not build something that is fit for purpose, that is fit for human dwelling. You can't be in a house and then the walls fall on you. You get, when those things kind of incidents arise, then the landlord will be liable in tort. So the landlord has a duty to ensure that the house is in a tenantable position where a human being can live. Okay, the tenant on the other part, like I said, the tenancy relationship starts from rent. Okay, the tenant must ensure that he fulfills his contractual obligation to the landlord to make sure he pays his rent as at when due. So both parties have rights and obligations, and when one party is in breach of his obligation to the other, then each of the party can go against the other to record or to enforce those rights.
Thank you very much. Now, the issue of rent, you talked about rent, and which I know that it is even the condition sine qua non, is a factor that relates or that creates the legal relationship between a tenant and a landlord. Now, is it justifiable for a landlord to just wake up one morning, just increase rent and say, tenants, your rent is no more 350,000, it's 400,000? Simply put, can a landlord now increase rent without prior notice to the tenant?
Okay, so to answer this question again, we'll go back to the tenancy agreement. So, subject to what the tenancy agreement says. If the tenancy agreement says the landlord can increase the rent at any time he deems fit, the tenant read that tenancy agreement and signed and agreed to that, okay, then he's bound by it.
There's not what the other tenant can do.
If he
is stated there in the agreement.
Yeah, because it's contract.
And you have signed.
You signed. It means you consented to it. However, it's the increment of rent in the absence of an agreement must be reasonable. You won't just wake up one morning and increase the rent. I think in some states they have a cap on the percentage increase a landlord can do. So I think some states will say that you cannot do more than 10% or more than 5% increase of the annual rent.
Okay.
Yes. So the landlord, if for instance the property is say 500,000 yearly, the landlord cannot do more than 10% increase. So he cannot increase
to 3 million.
He cannot do more than 5.5. I think 550,000 is 10%.
Yes.
So you must. So it's subject to what the law also says. And then the issue of notice. The landlord cannot arbitrarily increase rent without giving the tenant notice. This is generally at law.
Okay.
However, where the tenancy has ceased. Okay.
How do you mean tenancy ceased?
So if it's a fixed tenancy or if it's a yearly tenancy, okay, the tenancy has run out. Okay. Now there is a new term. The landlord will now say, for this new term, what I want the rent to be is X amount. Okay? The tenant has two options. To either agree to that new term or he moves out. Okay? But the tenant cannot tell the landlord, oh, this is what I must pay in the landlord's property. No. So it's subject to the agreement of the parties.
That's why we are saying from the beginning it's good that the legal instruments captured all these things to avoid all this.
Exactly. Because when it's contained in an agreement, whenever there's a dispute, the first recourse parties make is back to the agreement. What does the agreement say? The agreement will usually spell out the rights and obligations. A well-prepared agreement should do that, even though sometimes agreements are not well prepared.
Of course. Thank you very much, Council.
Thank you.
Now, we discover that oftentimes tenants, let me use the word stubborn ones, usually owe rent. You see them living there, in fact, telling the landlord there's nothing you can do. Now, in this circumstance, what are the ways or legal options by which a landlord can validly recover his rent? Because oftentimes you discover that those people, they'll be living maybe 1 year, 2 years, 3 years, no rent. Then before you know it, they were packed out without telling the landlord, maybe I've got to another place. What happened? Because this is investment. What happened? How will the law protect the interests of the landlord?
Okay. So the issue here is the tenant is under a contractual obligation to pay rent. Now, where he defaults in paying the rent,
You mean tenant now?
yes, the tenant, yes. Where he defaults in paying the rent, the landlord has statutory notices to serve on him. The notice to, okay, where he defaults in paying rent, the law is that what he's entitled to now is just 7 days notice of owner's intention. He's not entitled to notice to quit. That is subject again to the tenancy agreement. Depends on what the parties say. If the parties say agreed in the tenancy agreement that even when the tenant is in default, the landlord must still give him notice. If that is what they agreed in the tenancy agreement, then they must comply with it. But if that is not, but usually that is not the case, no landlord will have that kind of tenancy agreement. So where the tenant is now in default, what the landlord does is to serve him the statutory 7 days notice of owner's intention, and then he proceeds to court.
Okay, the 6 months is no more there. Once the person is now tenant at will. I think that's the one is tenant at will.
Exactly.
Please explain that tenant at will very well. Let's understand what we mean by tenant at will, because so that our viewers that are non-lawyers will appreciate what we're doing.
So a tenant at will is a person, or sometimes called a tenant at sufferance, a person who is holding a property, but the tenancy relationship has ceased. He's no longer, there's no longer no valid tenancy still running. But because in the law protects the tenant, you can't just go and throw him out of the property. So at that stage, the landlord now proceeds to court because the tenant is now in default. He's no longer staying there based on the tenancy agreement, but he's staying there based on the provision of law that prevents the landlord from throwing him out. Remember, we had discussed the last time that the landlord cannot use self-help. When the tenant, I was listening to the radio this morning, and somebody was telling a story, someone in Lagos, about a landlord who, because the tenant was owing, brought out a gun and shot at the tenant.
Yes.
I was listening to the story this morning. I was like, wow, nobody does that. It's the landlord can pay dearly for it. You don't do that. You don't use self-help. So what the landlord should do is that when the tenant stops paying his rent or refuses to pay his rent, you now proceed to court, because the tenant is a tenant at will. So you now proceed to court, and then you itemize the total amount the tenant is owing. And then there's also what we do. You now ask that the rent is now calculated on a monthly basis until possession is delivered up.
Okay.
So throughout the duration the matter is in court, the tenant will pay all the rent up to the day when he's ejected from the property. So what we do is that we file the matter at the court with jurisdiction. So there are issues of monetary jurisdiction of the court. In the FCT...
But quickly, before that one, Counsel, can you tell us why is it that the law in all things does not aid or support self-help? Because there's no place. Because oftentimes you see somebody who is pointing at your property that I'm not going to... And you will like... Why is it that the law does not? That's the question we are taking now.
Yes, so it takes us back to the social contract theory. It's one of the subjects of jurisprudence where man agreed to live a civilized life. So man agreed that he will be governed by rules and regulations. Before civilization, we used to live in a society where the strong will oppress the weak. Yes, but the social contract theory we've now come and agreed that we will all donate our power to the states, to the government, okay? Who will now, wherever we have a dispute, we will now subject or submit those disputes to the state for the state to resolve our issues. So we now agree that nobody will be brutish or roguish or be a thug. That you are a weightlifter or a strong person doesn't mean you can lord it over another person. So the state now takes charge. So that's why the law now abhors self-help. Okay? Whenever you are aggrieved, whenever you're unhappy, whenever you don't like anything, not just with landlord-tenancy relationship,
anything.
It cuts across all spheres of life. Whenever a person is aggrieved, you know that you can actually pounce on this person and tear him to pieces. But you can't do that. Because if you do that, you'll be charged for assault and you'll go to prison. Okay?
Just like the example you cited, because of self-help, look at the results now. Murder was committed.
Exactly. So you now follow the agreed channel to ventilate your dispute. So parties are not allowed to help themselves. You must, no matter how long it takes. We have a challenge with the justice system also, because some people will say, this process is taking too long.
Too long.
That's a legitimate concern, which I believe that the judiciary and also the NBA should look into, because we do some cases recovery of premises in Abuja 2 years, 3 years to recover possession for a property worth maybe 500,000. How much the cost of recovery of premises is even more than the annual rental value of the property.
This is becoming so interesting, but you're going to continue after I come back from break. Please do join us again. Hi, you're welcome to the speaker on ACNN television, reaching you from Abuja. On today's episode, we are going to be looking at the topic that says encouraging Nigeria or discouraging Nigeria. My name is Anozechi Nomsu. Encouragement is defined as the act of giving hope or support to someone. It is also that which serves to incite, support, promote, advance, and revive in order to boost or increase confidence to achieve a better result. This simply means that when encouragement sets in, progress and positive end is inevitable. It is therefore correct to say that anything short of this is better referred to as discouragement. When I look at Nigeria, when I think of Nigeria, with all that is happening, I do not know whether to laugh or cry. It is unfortunate that with all the natural resources and divine blessings lavished on Nigeria by God Almighty, I'm still persuaded to ask on whether we are encouraging Nigeria or discouraging Nigeria. In a situation where we have political leaders who uses Nigeria as a pawn on a chessboard, is a clear point to the fact that we are discouraging Nigeria. Where a governor of a state gifts the winner of Big Brother Nigeria with a befitting house, SUV, and huge sum amount of money, but merely took pictures with the best student academically, reveals a discouraging Nigeria. How can Nigeria be encouraging when young minds are not allowed to occupy positions of leadership? How can Nigeria be encouraging when great-grandfathers and grandfathers refuse to leave office? It is a wise saying that no matter how a good dancer you are, you must leave the stage at a certain time. But the politicians in Nigeria have forgotten that. The so-called stakeholders have forgotten that. This business of someone occupying a political office or position of leadership until he or she sees his or her great-grandchildren must stop, because it can only make Nigeria retrospective and stagnant. It is on this note I began to ask on the reasonability of appointing an old man of 83 years of age in the person of retired Justice Sylvanus Nsofo to be an ambassador of Nigeria to the United States of America, who later died at the age of 85 years, just 2 years of his appointment. What a shame. Nigerian politicians must be told, if they don't know, that just as the wave pushes the ocean in order to renew its purity, so young minds must push away old people in order to renew the society. It is because of all this that Nigeria has not realized our potential. When an Inspector General of Police who is due to retire and leave office still remains, only for Nigerians to get the shock of their lives that Inspector General of Police Muhammad Adamu tenure has been extended to 3 months to enable the federal government to make a robust and competent replacement, is an example of discouraging Nigeria. This decision is a monumental rape on democracy and a slap on the morale of thousands of police officers nationwide whose career progression has thus been put on hold. A situation where the immediate past service chiefs were all nominated as non-career ambassadors by the president barely 2 weeks after leaving office and sent same to the National Assembly for confirmation, is a perfect picture of discouraging Nigeria. The question is, Why the extension of the tenure of the IGP Abubakar Mohammed Adamu? Are there no more young minds that are competent enough to handle such positions? Why must impunity and political wickedness continue to occur in Nigeria on a daily basis? Why must evil and bad governance continue to thrive in Nigeria? Why must Nigerians continue to suffer in the hands of these conscienceless politicians? Why must injustice continue to prevail in Nigeria? All this must stop. Because if Nigeria continues in this trajectory, doom, destruction, and undevelopment remains our birthright as a nation. I look forward to the day, therefore, when injustice will be the exception rather than the rule, and justice the rule rather than the exception. I look forward to the day, therefore, when these old cargoes will leave office in order to create an opportunity for the young ones. I look forward to the day, therefore, when Nigerians will stop canonizing demons and demonizing saints. I look forward to the day, therefore, when Nigerians will speak the truth and nothing but the truth, no matter whose ox is God. I look forward to the day, therefore, when electorates in Nigeria will refuse to be bribed during an election in order to stop electing hyenas and lions to take care of the goats and sheep. I therefore speak. Until we all join our hands to sanitize Nigeria and exercise the ghost of favoritism, tribalism, religious sentiments, and ethnic extraction, condemn evil at all times, and promote righteousness and godliness in all we do, and further use our political willpower by using our votes to eradicate this old and poisonous blood from political offices in order to create positions of leadership to the young ones, we shall continue to have a discouraging Nigeria instead of an encouraging Nigeria. My name is Anozie Chinomso. I just want to speak. Hello out there, glad to know that you are still with us. We are still here with Barrister Obinonya. Thank you very much.
Thank you.
So before we went for break, you are trying to tell us about the issue of self-help, that the law does not aid to that, so that we will live in a good society. But moving away from that, looking at the subject matter on the relationship between a tenant and the landlord, you see that oftentimes that some tenants will be owing landlord. They say they are not going anywhere. And this is the property of the landlord. And you talked about self-help, that nobody should go and box each other. What are the legal steps by which he can recover even his money and his premises from a defaulted tenant?
Thank you. So the first advice I'll give to every landlord who finds himself in that position is to get a lawyer. It's not that the landlord cannot file the suit himself and proceed with the matter himself. However, there are technicalities which a tenant can use to keep himself, to perpetuate himself on that property. Because a clever tenant, for instance, can challenge the service of the notice. And when the court agrees that the notice, the 7 days notice is defective, you strike out the suit and you start afresh. And that could take another 1 or 2 years. So the best thing a landlord should do in that situation, get a lawyer, or get the advice of a lawyer if you cannot pay for one. And then the lawyer will now advise or prepare the 7 days notice, which will now determine or sever the tenancy relationship. Then after that, the landlord, the lawyer now proceeds to court. He files the requisite documents, the plaint in the High Court, in the Magistrate Court, and the writ of summons in the High Court. So with those documents filed in court, the landlord will now be put in the witness box, or any of his agents will be put in the witness box, and you tell your story, you tell how much the tenant is owing you, tell you if there are tenancy agreements, you tender the tenancy agreement and the notices, and with that you proceed to judgment. Yes, if the defendant or the tenant has any defense, he will state up his defense.
I think there's a limit depending on the jurisdiction of the court.
Yes.
So of course that's what the lawyer have to look at, so that he will know the appropriate law, the law court that will now take
exactly,
yes,
because,
that will entertain the matter.
That's one of the reasons we say
you find a lawyer.
Get a lawyer, because the lawyer that will know the court with jurisdiction. For instance, I just mentioned magistrate court and high court. Some persons can go to an area court for recovery of premises. Area courts don't have jurisdiction. Upper area courts don't have jurisdiction. Customary courts don't have jurisdiction.
So it's dead on arrival.
Exactly. And whatever order you get, because sometimes those
agents, they call them agents or caretakers.
Yeah, they would be telling you, oh, we'll get the order, There's one very funny order I saw the other day all over the internet. An order from, I think it was an area court, telling somebody to get out of the property immediately. Those things are not valid orders of court. So it's very important you get a lawyer. A lawyer will be the person, and even in the FCT, we also have administrative jurisdictions in the FCT. So a property in Lugbe, by the FCT practice direction now, generally, even though they are taking it to another jurisdiction, is advised to file in the court within the administrative
and judicial area
of the property. Yes. So those are the things a lawyer will be able to properly advise on. So it's important, get a lawyer, and then you take it from there.
Then counsel, when you now get a lawyer, and you see that oftentimes, maybe because of our legal jurisprudence, you see some matters 2, 3, 4 years. How can that be addressed? And this is the only life-saving or what I may call investment this landlord has.
Yes.
Is this still supposed to have faith in the law?
So you see, these are issues for the judiciary and the Nigerian Bar Association to really look into. The administration of justice is not encouraging. The time within which cases are turned over is not very encouraging. We still have cases for recovery of premises taking 2 years for recovery of premises. It's not impressive at all. Some adjournments, you go to court in January, the matter is adjourned to March. In March, the court will not sit. You give a date in June. In June, maybe the witness is not available. You find the matter taking longer than usual.
Judges, they are on vacation.
On vacation, and then you go on and on. So I think it's something we should really look into. Maybe and because this issue of recovery of premises is becoming becoming a problem in the FCT, maybe the FCT judiciary in conjunction with the MBDA, the Unity Bar, should look into it. Maybe they could create special courts for recovery of premises in the FCT. So you have magistrates or judges who sit specially for recovery of premises and make it timeless, so that within 3 months, 6 months, you're done with it, so that it encourages people not to, like that man in Lagos, pick up his gun and shoot at a tenant. You understand? So it's really,
and that's the criminal case now on its own.
Exactly. It has cascaded from recovery of premises to something else, because the man is frustrated. The man says, no, how can I go to court and spend 2 years on recovery? And I think it also should be people should be sensitized, really, because we need a lot of reforms. We need a lot of reforms in the justice sector, but this is one of such. And if special magistrate, recently I understand the FCT judiciary appointed 40 new magistrates. So I know that will go a long way in mitigating the issue of long
and giving accelerated hearings to things and all
because
that.
I have to be fair to most of these judges and magistrates, their dockets are overloaded. Sometimes you come to a court 15, 16 matters a day, and most of them are for trial. And each of the trial will take no less than 2 hours, 1 to 2 hours.
Yes, witnesses and all that.
By the time you take 10 cases, the judge of the magistrate is tired. They are human beings. And then they come the following day and continue the same routine.
So your advice is just total reform.
Yes, I must first commend the FCT judiciary for the 40 new magistrates that were appointed. I know it will also lessen the burden on the extant ones. And then they should see that magistrates should be encouraged, the judges also should be encouraged to see that matters of this nature are expeditiously dealt with. And even the rules could also be amended, because you see, if a tenant is owing, he's owing. One of the ways to accelerate it is to maybe the district court rules could be amended to say, if a tenant admits his own, I know there are provisions for the issue of default judgment. When a tenant admits yes, his own judgment is entered generally. But when a tenant does not have a defense to the action, they should be encouraged to say, okay, give me 2 months and I move out. Those procedures should be encouraged but there are some courtrooms you go to and the court will say, no, we must proceed to trial, and trial will take years.
Yes.
This procedure, these adjustments will help accelerate the course of justice.
Thank you very much. Just in less than 1 minute, how can now a tenant recover certain renovations that he has made from landlord? You know, oftentimes you come to a place, it's not habitable, he uses his money and his efforts, and asking the landlord, he said no. Now, how can the landlord protect the tenants now in getting some of those cost of renovations? Just in less than 1 minute.
Okay, so there is what we call a counterclaim or a cross-claim. So where a tenant has made improvements on a property, he must have made it with the consent of the landlord, because if you did not get the consent of the landlord to make improvements on his property, you're on your own. Okay? But if the tenant got the prior consent of the landlord to make those improvements, then the landlord agreed, oh, okay, I will set it off from your next year rent, or I will refund you when you're leaving, then he can file a cross-claim or a claim in itself for the recovery of those monies. I will also advise the tenants in this case also to get a lawyer.
Thank you very much.
Thank you so
We heard it
much.
from him. Just both the landlord and the tenants get a lawyer because they know what to do. Want to appreciate you, sir, for coming.
Pleasure.
And I pray next time we call you, you are obliging us
Thank
to
you
come.
so much, sir.
Thank you very much.
Thank you, sir.
It remains a statement of fact that it is a joyful and wonderful thing to own a property or properties, as the case may be. But when leasing any of your properties to any tenant, make sure that you as a landlord comply with all the covenants, terms and conditions of the agreement. It is also advised that a tenant should endeavor not to be in breach of any part of the agreement. This is because the law is for both the landlord and the tenant. Furthermore, when you are seeking justice on any law court that has jurisdiction to entertain any matter relating to dispute between a landlord and a tenant, make sure that you are not in violation of anything by keeping to your part of the agreement. For he who comes to equity must come with clean hands. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, this is Anoze Chinomso wishing you the very best, and bye for now. Every person who is charged with a criminal offense is entitled to defend himself in person or by a legal practitioner of his own choice.
Remember that an individual is entitled to remain silent.
Every citizen in Nigeria is entitled to maintain a private life.